Thank you. And my name is Erick Giles. I am from the law offices of Drummond Woodsum. And today my topic is discussing medical cannabis and industrial hemp. I am from the Muscogee Creek Nation of Oklahoma, and I was a former member of the Indian Land Tenure Foundation. And today we'll be discussing the topic of cannabis broadly, and then some of the uh, specifics about cannabis regulation. So hemp and marijuana, uh, they are names for the product from produced from the same plant, cannabis sativa. Under the U.S. Controlled Substances Act, the cannabis plant itself is illegal. In addition to products produced from the plant, hemp generally refers to the plant that are low in THC, and while marijuana refers to the varieties that are high in THC, which is a psychoactive component. The line between hemp and marijuana is based on a 0.3% THC content by dry weight. Below it's hemp, and above that's what is marijuana. Weed is classified as a Schedule 1 drug. Therefore, anyone who is producing, selling, or consuming weed, the weed product, is committing a felony. More recent public opinion has shown that there is broad support for legalization of marijuana. And in fact, in 2018, under the Farm Bill, hemp was legalized and um, uh, regulated under the U.S. Department of Agriculture. And it's a regulation system where tribes can submit a hemp regulation plan to the U.S. Department of Agriculture, and that can be approved. And then the tribe can assert regulatory authority over hemp production. Um, Marijuana or cannabis in this poll here, I mean, you can see that it's has a 60% support for legalization. This is back in 2016. More recent polling shows that it's actually up to um, around 60% for recreational adult use and about 80 to 90% for medical marijuana. So it's very a change in more recent times that's shown that there's just a consensus across the country about legalization. As I mentioned, marijuana is a Schedule 1 substance under the U.S. Controlled Substances Act. Um, Under the Obama administration, the Department of Justice, they produced a series of policy memos for U.S. attorneys um, regarding the non-enforcement of marijuana legalization efforts. And in states that had legalized marijuana under either recreational or medical use, these Cole, or what was referred to as the Cole memo and the Wilkinson memo that applied to tribes specifically, was that there was not going to be enforcement of the Substances Control Act against those states or those tribes that were acting consistent with state legalization efforts. Under the Trump administration, they rescinded those memos, but in the Biden administration, we believe that that pattern of non-enforcement will continue. It's under a federal appropriations act that gets approved every year, but basically it's an amendment that started in 2014 and has been renewed annually. But it's an amendment that prohibits the Drug Enforcement Agency and Department of Justice from prosecuting persons who are acting in compliance with state medical marijuana laws. Just some recent, I guess, trends from the Biden administration. What we hear is that Biden favors rescheduling marijuana from a Schedule 1 drug to a Schedule 2 drug. Vice President Harris has more of a pro-cannabis legalization. She supports full legalization of cannabis. In Congress, there are a couple pieces of legislation. There's called what is known as the Safe Banking Act, and it would allow state and federally licensed financial institutions to invest in marijuana facilities and not be subject to any legal liability. The other is the Marijuana Opportunity Reinvestment and Expungement Act, and that would remove cannabis and marijuana fully from the Controlled Substances Act and would allow states to decide how to legalize marijuana or cannabis. So, as I mentioned, under the Farm Bill that was passed, it had removed hemp from the Controlled Substances Act, and hemp, again, it's under this 0.3% THC on a dry weight basis. So hemp would have to, your product would meet that threshold of the THC level. And the Farm Bill handed over regulation of hemp to the U.S. Department of Agriculture, and the USDA came out with regulations for enabling tribes to develop what are tribal regulations and tribal hemp plans. And essentially they are plans that are submitted to USDA, and I am showing right now a hemp plan from the Blackfeet Nation, and under Blackfeet, you can see that they have a resolution from the Tribal Council, enabling hemp production on the reservation, and the kind of the guidelines for developing these plans is, USDA, they want to see how the tribe is going to be licensing and regulating, how hemp products are going to be tested, and what are going to be the enforcement mechanisms put in place to ensure compliance. And essentially, I guess what will happen is tribes will be engaging in hemp production, and after a few cycles, USDA will conduct an audit of those tribal regulatory regimes, and to see how licensed hemp producers are complying with those tribal production plans. To date, there's been quite a few tribal hemp plans submitted to USDA, and they've gone across all across Indian country. And like I said, you can see there's Blackfeet, but there's in Oklahoma, California, Montana, in Midwest and Minnesota, and in the Dakotas region as well. So tribes that want to engage in marijuana regulation, cannabis regulation, there's a couple, a few ways to get into this. And here you can see the kind of matrix of the status for tribal regulation. You can be in a state where the state has either passed a medical marijuana law or uh, adult use law, and the tribe could then, since because the the decriminalization under state law of cannabis now becomes what is a civil regulatory matter. Tribes can exert that same type of control over the same over cannabis if the state is doing the same thing. And it's the same analogy as gaming, where the state is taking gambling and making it a civil regulatory matter. Tribes can utilize gaming under a civil regulatory matter as well. Here's the same. It's the same issue. So state engages in decriminalizing marijuana and passes a medical marijuana law. Legally, the tribe would be able to pass its own medical marijuana law and start regulating medical marijuana on the reservation. There are kind of three, I think, models for the tribe to engage in. One is, the low risk option. They could develop a compact with the state and negotiate the rules that the tribes wants to operate their cannabis, whether they want to engage in production and retailing, or if they just want to have retail shops. Under a compact system, they could, take advantage of state license facilities to import cannabis to a tribally owned and operated cannabis retail facility. So that means that they would just be importing the final product to the reservation, and they could, buy from a state licensed grower, and then that product would then be tested under a state licensed facility, and so they know that that final product coming for retail is really kind of on the up and up of being a quality product that meets, a consistent guideline for potency and those testing thresholds. Another alternative that the tribe could engage in is it could open a facility under state licenses. So if the tribe had a Section 17 corporation, or in Oklahoma, I think it's a Section 4 corporation, but these are federally chartered corporations. Within that corporation, they could form a subsidiary LLC, and then that LLC could then go out and obtain a state license to be a grower or retailer, and they could locate that operation on fee land if they decide to, but they're doing everything in compliance with state law. The third model, which is the kind of the, in my opinion, is the more pro-sovereignty model, would be where the tribe engages regulating and the production of cannabis through a vertically integrated operation, where all the activities, the growing, processing, and retailing all occur on the reservation on tribal land, and they could be doing this with without a memorandum of understanding or a compact with the state, and they're doing this to preempt state law. Again, because this is a civil regulatory matter, and so when it's a civil regulatory matter, in the absence of federal law, the tribes can engage in the same level of activity as the state. Now, there are examples where tribes have tried to, develop their own facilities without a compact in a state that has legalized cannabis, and when they've gone kind of beyond the scope of being consistent with state law, they've they've encountered issues with state and local law enforcement. One example I understood was the rancheria in California had there are growing limits for how much cannabis could be grown under state law, and the rancheria was going above those growing thresholds. And the Bureau of Indian Affairs and the state and local county law enforcement did conduct raids on the rancheria on tribal land. But that example is one where the state has legalized it. Another one was in South Dakota, and the state of South Dakota had not legalized cannabis under a medical or adult use, and the tribe was anticipating opening a marijuana resort, and it did run into federal law enforcement issues. But I think what that shows is one of the best practices that if you're in a position in contemplating this process, is to just have an open dialogue with the U.S. Attorney's Office in the state that you're in, and with the state attorneys as well. That way, everyone is nobody is surprised. The tribe is coming to them and saying, "Look, this is what we're going to do. Here's our laws that we've drafted. This is how we're going to regulate. It's going to be in a way that's going to we'll have a regulatory authority. We're going to be planning. These are the operations we're going to do. We're going to do growing, processing, and retailing, and it's up to you whether you want to negotiate something, an agreement with us. But this is how we're going to approach this." I think those are the three ways to approach this, and asserting jurisdiction in Indian country is really important, because there's just if you have that opportunity to assert civil regulatory control over a certain matter, that only enhances and grows the tribe's sovereignty, and so we want to make sure that we engage in that. What else that the tribe could do under a regulatory regime where it's doing everything under tribal law, pursuant to tribal law, is that the tribe doesn't have to be in the business of growing and retailing. The tribe could just serve as a regulator and enable its own tribal members to they could issue licenses to tribal members who want to develop a business, a cannabis business, and those cannabis businesses could be developed individually on an allotment, or the tribe could lease out a portion of its tribal lands to tribal members to develop these businesses, and the tribe could just be in the position of regulating, but also potentially maybe guaranteeing any financing, utilizing those powers of the tribal government. Um, I think that's those are the ways that we can get into this. I would want to say though that um, under uh, under tribal law, um, you really want to get to that threshold of generating value on the reservation, and that's where your argument is strongest of preempting state law. I don't approach these issues in that we are going to comply with state law, or we should do whatever the state allows us to do. I'd like to see us in a way that we are enhancing or exerting our sovereignty to the greatest extent possible. And so you do that through generating value on the reservation. Um, and and like I said earlier, it doesn't have to be solely through the tribal government. It could be through tribal members, um, or it could be through a leasing program where the tribe is leasing a portion of its land to a outside investor who will build either a retail facility or the whole vertically integrated operation. Um, uh, and if it's done under a Section 17 corporation, which is it's a federally chartered corporation under the Indian Reorganization Act. That lease is, if it's being leased out by that corporation, that for a period of initial term of 25 years with an option for another 25, so a total of 50 years. But that lease is exempt from BIA review. In the individual Indian context, as an allottee, if under tribal law, you were to define cannabis and cannabis products as agriculture products, and present this as an agriculture use. Agriculture leases for a period of 10 years or less, that has the ability to be exempt from BIA review and approval as well. Those families could then, they would get a designation for agriculture production from the BIA, and then any subsequent leases that were made that were again for a term of 10 years or less would be exempt from BIA review. So I already, kind of talked about this, but this is what I was getting on, is the administrator approach for the tribe, where they're enabling licensed operators, which would be tribal members, and they're conducting, they're building out grow facilities, manufacturing facilities, and retail facilities. Now, in this process here, what is left out though is the testing facilities. Testing is a really important aspect to this, because you want to make sure that the product that's being produced is at those at the potency that it says it is, and you want to make sure you're producing a quality product. So in this administrator approach, here you could have the tribe is regulating it, but maybe where it comes into play in the supply chain of this is that there is a tribal testing facility, so that individual members who are conducting these operations could send their testing sample to a tribal facility that's run and operated by the tribal government, and then they can this would help because there's an issue where if the tribe is doing this on its own, um, it's a gray area as to whether they can utilize state licensed facilities, and you want to make sure that you don't have, if you're going to do this on your own, that you're not in conflict with anything regarding state licensed facilities. So um, I think that would be maybe a gap that the tribal government could fill if they were to engage in developing a testing facility, which I understood is in the range of about $10 to $12 million to produce. The operator approach, that is where the tribal government is engaged as a business. It's developing a vertically integrated operation from seed to sale, and it's regulating everything on its own on tribal land. It obviously would have potential preferences for tribal members to be employees, but that's the operator approach. And so here's just some visuals as to what this looks like. Here's a grow facility. Here's the plants that are maturing and conducting ready to harvest. Here's what they look like after the harvest. You see all the fans that are drying them. Here's the trim room as they're beginning to process the flour. And then here's a clone room where they're actually replicating those plants that are at a certain, if they're hybrids or a certain type of product, they can clone those seeds so they can reproduce those. And then here's what the final packages with a retail sale would look like. This is a piece of equipment that's used to create certain types of extraction products that are concentrates and tinctures, edibles. And so you're really getting to the point in a retail facility that it's no different than any other basically any other retail sales operation. So that something I was if this was a retail facility, something to look at would be that you could then potentially integrate these with gaming operations or other economic development efforts. And I think as this becomes the market becomes more mature and legalization becomes more prevalent, it's a very complementary feature to existing economic development enterprises that are existing on the tribes. Wanted to mention a little bit about employment law and issues with cannabis. In the workplace, if you're a tribe and you're located in a state that's legalized adult use marijuana, as an employer, you're still able to prohibit marijuana consumption, possession at the workplace. You can still prohibit employers from showing up under the influence of marijuana. But the issue, I think, going forward is for tribes would be how do they test when employees are consuming off hours from the workplace. And so that's an issue that I think tribes will start to re-examine their workplace drug testing laws, as well as their hiring laws as well. But but this is this has just been our overview. I have a link in here to the National Indian Gaming Association. We recently did a show on the business of cannabis if you're interested in learning more about this. But um, I'm happy to answer any questions and appreciate your time. Mado.